Welcome to the L&M Medilaw podcast. Craig's Case Checker is created to keep you up to speed with the law of medical negligence, whether you're a solicitor, student, or curious observer.
Hello and welcome to Craig's Case Checker. Now, some of you may be pleased to know that I'm not going to speak non-stop for over an hour. As an alternative, as a reward maybe for all you devoted listeners, I have a very special guest with me today, Elizabeth Rose, founder of L&M Medilaw. And today we're going to talk about the case of PATERSON versus LANARKSHIRE Health Board, and it's PATERSON and others, I should add at that point. Now, I want to highlight here that Elizabeth was the solicitor for the pursuers in this case, and the successful one at that. So I think it's only apt that we have Elizabeth here to take us through the decision, the general facts, and of what is undoubtedly a tragic case for the family. But just to take us through what Lord Arthurson also decided in the end, and what were the critical points in terms of the decision, and in terms of negligence and causation, etc., etc. And hopefully from there we can maybe just discuss a few points sort of arising from the decision. So, no, Elizabeth, welcome to the show.
Thank you for having me, Craig. It's great to be on. And yes, I acted for this family for 6 years in total. Mm-hmm. It required a lot of preparatory work, a lot of investigative work, and as you know, involved the incredibly sad story of a suicide which took place in the community following discharge from an inpatient setting from Hare Myers Hospital. It was an extremely sad case, and I think what made this different to some suicide cases is this happened 24 days after discharge. So there was a significant period of time between the date of discharge and the completion of suicide. Yeah,
that was a crucial point in the end, wasn't it?
Yes.
I mean, we'll talk about the precise circumstances, which I think can more or less be summarized as you're doing there. But we, L&M Medilaw, weren't exactly looking at the decision to discharge. It was more, as you say, the period of time.
Yes, it was to do with really what we would deem as aftercare, a support package, and whether it was competent. Now, the main thrust of our argument is that there wasn't a safe care plan for Lynette Giblin, and if there had been, that this would have avoided the suicide. Now, this is fairly controversial, as the defenders felt that you could not apportion responsibility to the treating psychiatrist for what they perceived as an impulsive act and something that couldn't have been foreseen. So it was very much focused on the factual sequence of events following the date of discharge, what was said during the discharge plan, what was written down and what was documented, and what contact Lynette had with other agencies over that 24-day period.
Yeah, and I think it's worth adding some context to why the discharge and the follow-up was so lacking in the end. Why we were critical of it. So if you wouldn't mind explaining just briefly Lynette's background with mental health, because as many will see from the decision, it was quite significant.
Yes, so she had EUPD, emotionally unstable personality disorder, which is a condition that can wax and wane, and it is quite a chronic psychiatric condition. Unfortunately, there was a triggering event which resulted in a deterioration of her mental health, and that was a criminal case that she was involved in, and which collapsed. And she was the complainer, the victim in that scenario, and unfortunately the case collapsed, and that was a trigger in terms of her mental health becoming poorer. She then had a period of various inpatient admissions, and 2 failed discharged, and that she had to be brought back to the psychiatric facility because she was unable to cope in the community. So there was a significant history of psychiatric illness. And what made this presentation different, the August presentation different, was the fact that she was starting to experience psychosis and more active psychosis. And this was incredibly distressing for Lynette. And our argument was that when the feature of psychosis, this should have been heavily monitored within the community. And our expert psychiatrist, who was wonderful, Dr. Charles Musters, an excellent consultant psychiatrist, he felt that she merited a crisis support package, which would have involved things like supervised medication taking, and so that the community mental health team would go out and monitor her taking her antipsychotics, taking her medication, and that she should have had a full package of support following discharge. Now, unfortunately, that didn't take place. Not only did it not take place, it flew in the face of national guidance at the time. So there was Sorry, go ahead.
Sorry, Elizabeth. And the thing is as well that from what I can recall from the judgment, and just discussing it with you as well, that she had this significant history of mental health difficulties, and the risk of suicide with respect to that tended to fluctuate as well.
Yes.
Around that time when she was discharged. What was Dr. Musters' position on that?
So Dr. Musters' position was that she was always at risk of suicide, and the defender's expert accepted this. The defender's expert felt it was a lifetime risk. However, Dr. Musters felt it was fairly acute risk in the context of there being several failed discharges before, and the level of her distress had manifested in more acute ways, in that she was extremely upset on the ward, and she required intensive psychiatric care input, and she, there was restraint, etc., used, which is at the very, very extreme end of mental health support. So this was someone that we believe was very, very much at risk and was very much vulnerable within the community. And that a full risk assessment should have been completed and should have been more robust than what it actually was. And NICE guidelines at the time were saying that you needed some sort of follow-up within 7 days. Now, as you know, her outpatient appointment went beyond the 24-day mark, and by that time, she had already completed suicide. And there was no good clinical rationale that was led from Dr. Vizicala during the proof, which indicated a reason from this departure from normal and usual practice.
Yeah, and if I remember rightly with the defender's expert, forgive me if I get the name wrong, Dr. Muzaffar, is that correct?
Yes.
They were saying that based on the records and the previous history, they figured that Lynette's risk of suicide was low, but changed that upon hearing Vizicala's evidence.
Yes, so they changed that to, I think, moderate or medium risk during the course of the evidence. They never put it at an acute risk or a significant risk. We disagreed on that. We felt there was enough history there because there was previous incidents of self-harm and quite significant episodes of self-harm. So we felt there was certainly a history and a recent history that should have been taken into account when doing a risk assessment.
And I remember as well that it appeared as though the defender's expert, and I don't mean to be bashing their experts, we would need to try and take a balanced view here, but in the end, I think one of the flaws of their evidence was that in their reports, they had actually omitted a couple of significant entries with respect to Lynette's mental health, and I think involved suicide attempts or self-harm at least.
Yes, that's correct. And this is, for practitioners, this is advice I would give anybody. make sure your expert report covers all the medical entries, because if they don't, you are going to be cross-examined on it at proof. And this is what ultimately happened, in that there were critical entries not reviewed and not contained within the report. So when they were put to the defender's expert, she was on the back foot.
Yes, absolutely. And yeah, so it was clear Lynette's history was very significant. There was an acute risk. And we'll come back to this point later, but I think there seemed to be a common sense view, certainly with the perceivers, that the risk was high. Now, I think the background certainly gives plenty of context to what was ultimately decided here by Dr. Vusikala. So if you could briefly explain what he had decided and why. I mean, I remember he couldn't really explain his actions, which was unfortunate. I believe partly down to caseload.
It was difficult to understand the rationale of Dr. Vusikala. And I think one of his responses in cross was, "I don't have an answer for that." So it's difficult to fully understand. I think I would be speculating, because it wasn't clear in his evidence what the position actually was. I think perhaps there was a diary issue, and that he originally wanted to see her within 2 weeks. That seemed not to be possible. And then it went further than 2 weeks, and went almost to 4 weeks.
I mean, and sorry, Elizabeth, I understand as well that from the evidence that he and the community psychiatric nurse, Hume, I think it was, had discussed this and felt that 24 days was appropriate.
Yes. And it was felt appropriate that Nurse Hume's appointment be at the same time as Dr. Vusikala's. And I think our experts felt that was unusual. And I think Dr. Musafa thought that was also unusual, that the CPN appointment, because bear in mind, the CPN support is very much a community support. It's a community psychiatric nurse. And they are able to go to people's houses, etc. And it was unusual that had waited until the outpatient appointment. But obviously, in Nurse Hume's defence, he had gone and spoke to Dr. Vusikala. They'd had a conversation, and Dr. Vusikala is the named responsible consultant, and it was agreed that that was appropriate. An argument was that it wasn't, but ultimately it was Dr. Vusikala's responsibility at that point to intervene.
Yeah, and if I remember rightly, and this is noted in the decision, so it's not as though I'm disclosing anything which isn't already known, but there was a case initially against Mr. Hume with respect to his actions or lack thereof, and I suppose would that have been primarily down to the fact that Dr. Vusikala was in charge, he was calling the shots.
Ultimately, the named consultant is captain of the ship. There's other support mechanisms in place, like CPNs, in some cases OT. But ultimately, it's the named consultant that is responsible. He is the captain of the ship. He is there to negotiate and implement a safe care plan, and it is his responsibility.
Yeah, absolutely. And I suppose the question then becomes if a reasonably competent community psychiatric nurse in those circumstances would call that into question or second guess a consultant. I suppose the answer to that was simply no. Everyone would just follow the captain, as you put it. So moving on from that point, so Dr. Vusikala was quite candid in his evidence with respect to what was determined for Lynette, and from my own observations of the evidence, I think that may well have been the turning point. Although it's having said that, I think Dr. Muster's evidence seemed to have a significant impact on Lord Archerson's reasoning.
Yes.
I mean, what was quite interesting, I noticed, was Dr. Musafar had referenced the NICE guidelines, and I think wasn't there an argument by the defenders that the NICE guidelines we were, and I say we, the pursuers, were relying on were dated August 2016, and the argument went that because they hadn't been fully implemented by the time of Lynette's suicide, they didn't apply?
Yes, it was applicability. It's the first time I've seen in a Scottish case the argument that NICE guidelines aren't directly applicable to Scotland, because NICE guidelines, so NICE and SIGN work alongside one another, and that if they're already covered in NICE guidelines, sometimes the SIGN guidelines won't cover them, and they're very much used by Scottish clinicians interchangeably. And in nearly every single medical negligence case that I have, NICE guidelines are lodged as a production, and it is good practice. So it was unusual that was the argument. And I think the other argument was that there wasn't enough time for Dr. Vizicala to digest this new guidance and implement it. But our argument was that the thinking behind the guidelines was very much already in practice. And NICE was just a formalisation of it. So really, it was something that you should have already known, in that having this condition makes you an acute risk to suicide, and that anybody that's been discharged from a community psychiatric facility is at risk of suicide, and an increased risk of suicide as to oppose someone who hasn't been discharged from an inpatient setting. And these were all accepted principles and known within the psychiatric community. And that was our point. Yes, the NICE was a formalisation. Yes, you might not have had time to read the guidelines in full, but at the same time, this was stuff that we already knew. It was old news. It wasn't new.
And I suppose the analogy could be drawn where if a new piece of legislation comes into play, we can't turn around 2 months later, having breached it, and say, "Well, I hadn't read it, so I wouldn't know." I mean, as you well know, lacking knowledge of the law is not a defence.
No. I thought that was quite funny, because lawyers are held to a very high standard there, in the sense that the responsibility is on you. And if you miss something, you miss something. And it's almost strict liability there.
Well, I mean, in the end, it's down to professionals. And, you know, I say this in a general sense, that you keep up to date with standards of your profession. So I have to say, I did find that an unusual line to take for the defenders. And especially when some of the guidelines which were being, for lack of a better phrase, fobbed off by the defenders, was relating to the logistics of setting up a follow-up for Lynette, if I remember rightly. So these NICE guidelines were saying there should be this follow-up in 7 days, but for particularly bad cases like her, 48 hours. And I can't say I've seen the guidelines from before those, but was that omitted, or was that already there? Why were they taking that view?
So I think because they hadn't been formalised in that way in terms of 7-day follow-up, it was always accepted that people who are discharged from an inpatient setting are an increased risk to suicide, and that there's certain chronic conditions that make you even more at risk to suicide, things like postpartum psychosis, etc. So there's certain conditions that are known to psychiatrists, but I think my understanding is that this was the kind of official formalisation of an agreement and a consensus within the community that a 7-day follow-up is appropriate. But obviously our expert, Dr. Busters, said that this was already known in patients like Lynette. It was just that the NICE guidelines was extending this to everyone.
Yes. And I mean, this is again, for practitioners, especially those who are not particularly experienced in clinic, yes, there is a certain reliance on NICE guidelines and SIGN guidelines, but they're not the be all and end all with regard to duty of care. In the end, So you can depart from NICE guidelines if you have good clinical rationale and good clinical reasoning. So they're not strictly enforced in terms of the strict liability if you don't follow them. But you do have to have a clinical reasoning. So if we apply this to this case, Dr. Vizicala didn't have good clinical rationale for the departure. And that is the crucial point. If he was able to lead evidence on the fact that these are the reasons why I departed from this, and there's a good clinical reason, and that was supported by their expert, that's a different story. But he didn't have that clinical rationale, and that's what's so important. So for medical practitioners, yes, you have discretion, but you have to have good clinical reason to depart from what's accepted practice. Yes, and in the end, when the court's assessing these things, they are making reference to what a reasonably competent such and such would do in those circumstances, or if in England, what a responsible body of such and such practitioners would do. And it seems clear to me that what ought to have been done with Lynette was already well established as responsible practice or reasonable practice. Yes. So, but as you say, the NICE guidelines are reinforcing that as a as the standard to go by, unless there's, as you say, any good clinical reason to avoid it. I mean, and from that perspective, it's difficult to understand how the defenders could have come to any view on duty of care being breached or not when Dr. Vusikala didn't seem to have any rationale behind what he was doing other than, as I say, he seemed to be a bit swamped, or there was a diaring issue.
Yeah. I mean, I think our case was always going to be stronger on breach of duty. I never had serious concerns about that. Causation was different.
Yes.
And I felt causation was this, and if I was thinking like a defender, would be the stronger aspect, disputing causation, because we have to accept that suicide can be unpredictable, and cannot always be foreseen, and we do not know what's going on in people's minds, and we cannot expect psychiatrists to know that in all cases. But we try to differentiate that in that there was a clear pattern emerging.
Yeah, this is it, and I think that's one of the primary topics that arises from this decision. And you're absolutely right that psychiatrists in the end are not mind readers. They're just giving people the means to try and manage their emotions and whatever else. And the typical defense, and I can speak for both of us here, I think that the typical defense in suicide cases will be, well, we couldn't possibly have known that they were going to do this.
Yes.
I mean, to your mind, what do you think the significance of this decision is? Because I mean, to my mind, I can't think of a more recent decision about causation in suicide claims. And what's also very interesting in Lord Arthurson's decision is that he makes reference to a case that you were also previously involved in Andrews versus Greater Glasgow Health Board, that causation should be addressed in a more common sense approach, as opposed to just dressing it up in all this medical terminology and legalities, and which just confuses everyone. You miss the wood from the trees, in other words. I mean, so going back to the first point there, I mean, the general significance of the case for suicide claims. I mean, what's your view on that?
I think it was when I saw Mr. Andrews' case being endorsed. I mean, that made me happy, because obviously Mr. Andrews was my client, and that also was a hard-fought case. And I felt, I believe it was Lord Pentland's view on causation was common sense, that it's impossible for the pursuers to, completely pinpoint that turning point, that moment, and then be able to categorize exactly what would have happened at what time exactly.
Yes.
That is setting up the pursuers for failure, because we don't have, this is a hypothetical scenario that we're running on. We're running on the counterfactual. If competent care had taken place, what would that have looked like, and what would have happened at this date? And there's only so far we can go. And to say otherwise is completely unfair. We already have a very difficult test in Hunter and Hanley. It's very difficult as a medical negligence practitioner to successfully prove these cases. And causation can be a huge sticking point in that we have to show the counterfactual. We have to show what would have happened when. And that's difficult, because obviously the experts that you're working with don't work in that health board.
Yes.
For obvious reasons, so they can remain independent. So I was very pleased when I saw George Andrews' case being endorsed, and I think it's completely viable to do and to utilise a common sense approach, because we're dealing with human life. We can't be completely exact in what we're saying, but what we're saying here is a pattern of behaviour has been established, it's documented, she has all these contact with agencies where she's deteriorating. Witnesses are giving evidence saying she's as worse as ever, we're so worried about her. You know, Lindsay McQueen from Women's Aid spoke very eloquently on this. She was a fantastic witness, and she was an independent witness. I think she was actually it was the defender that led her as their witness.
Yeah, that was the curious feature of that one.
Yeah.
And no, and I completely agree. I mean, it's just funny. You seem to be this trailblazer for common sense in medical negligence, which it can only be a good thing in the end. It's you and I both know that for a lot of these cases, they fall at the hurdle of causation because of technicalities, more or less. But I mean, in turn, I think this whole notion of common sense causation, I believe, derived from the McGee versus National Coal Board, which is, as you'll remember, is a asbestos-related case. But yeah, no, I mean, from a pursuer's perspective, long may it lived. Obviously, defenders won't like that.
No,
idea.
of course they won't.
You know, and I'm not going to pretend I know how they feel about it, but no, I do feel that it's very important. And just from a general, more, I suppose, social aspect, I mean, do you think, I mean, this is complete conjecture on our part, I suppose, but decisions like this, do you hope at least they may have some kind of impact on the provision of funds for mental health services? I mean, we may be kind of tiptoeing into politics by this point, but just from an overview of these things, because I think Lynette's case to me is a vivid example of where that service is really struggling.
Yeah.
And unfortunately, poor souls like her are falling through the cracks.
Yeah.
I mean, what do you think?
If this has a positive impact on any individual leaving a psychiatric facility, I would be over the moon, absolutely over the moon. And if I can even indirectly impact positive change, I would love that to be the case. In practical terms, obviously, we can't pretend to know the resource restraints that the NHS must experience and the difficulties that it must experience. It is a difficult job. You are on the front line, dealing with very difficult and challenging situations. But I think it is a stark reminder as to what happens when you don't give good packages of care. I can see my wee one in the background.
Making the star appearance, I see.
Yeah. But yes, I think it's a stark reminder as to what can happen if you do not have robust support care packages. And anything that can be done to increase those care packages is obviously going to be beneficial.
Yeah. I mean, and the thing is, this case, when it came out, was reported in the news, including national news. And as you say, you can only hope that it has that positive impact. Of course, everyone's feeling the pinch, and I'm not in a position to say what should or shouldn't be done with that sort of funding. But here's hoping, because in the end, mental health is becoming, well, I'd like to think, less and less taboo.
Yes.
And people really shouldn't be feeling ashamed about coming forward over these things. I mean, we do get the odd inquiry where suicide is not the result. It could be the psychiatric injury, as you know, is quite often a head of claim. But yeah, fingers crossed it makes that positive change. But at least you can say you've contributed positively to that conversation. And Lynette's death is not in vain in that respect. We've discussed the whole kind of common sense approach with causation, and I think, I don't think there's much more to be said. I mean, in fairness, Lord Arthurson himself doesn't really go into too much detail. What's interesting about his decision, it's quite brief for a case of that size and for how long.
I think it's 36 pages.
Yeah.
And I think George Andrews was about 60, I think.
That's right.
But then, you know, in a strange way, even though it was a complicated case, the evidence came out in quite a straightforward way.
Well, the solution was simple in the end, wasn't it?
Yeah. Mm-hmm.
So, you know,
So I think he probably felt he addressed what needed to be addressed. And obviously, what I really liked about the judgment is it was a humane judgment. That's what one of my colleagues, actually, one of our colleagues said, it's a very humane judgment. And I completely agree with his analysis of it, because the start of the judgment is paying, tribute to her as a person and humanizing that there was a person in this process. She was important. She was of value.
yeah.
She was loved. And I think that was so important to hear that. Even if we hadn't been successful, that was meaningful to the family, and the family appreciated that.
Yeah, and this is it. It's quite often, these cases are quite often cathartic for families. And again, you and I will both know that when we get fatal inquiries like that, the families who come forward usually want to pursue it out of a point of principle more than anything. And obviously we can do no more than get them compensation. But if it goes all the way like this, I suppose that's a good way of getting that sort of, I don't want to say revenge. It's not about revenge in any way, but it's at least they're
it's about justice. It's about justice, and it's about accountability, and it's about someone listening to them and someone explaining what had happened, and an independent forum looking at something and identifying whether there's failures and whether that has materially contributed or caused that person's injury or death. And I think that is really, really important, because a lot of the time the internal complaint processes are unsatisfactory for the family.
Yes.
This for them to actually understand what has happened and what, why it's happened, when it's happened.
Yes, and this is it. It's and that's, again, not trying to step on toes or make anyone annoyed over this or come across as partisan, but it's often a complaint you do get from clients that the complaints process itself just didn't really help in the slightest. And it's not particularly cathartic. They don't know any more than they already do about what happened and why things were done. But I digress. Now, I suppose the final point we could maybe go on to, which I think is quite interesting, arising from this decision, is the actual awards made by Lord Arthurson. Now, for those of you who are not so initiated, in Scotland, we do sometimes have jury trials for these kinds of cases, and typically you'll find juries will award more than what a judge would. However, in this case, from what I can see, and based on developing jurisprudence in this area, that gap appears to be closing, I would say.
What I would say is distinctive about this case is obviously with Mrs. Patterson's award, her situation was fairly unique in that she had a very physical manifestation of stress following what had happened. So I think hers is distinctive in that way. But yes, I think it's a move in the right direction. I'm always going to say that as a pursuer solicitor.
Sure.
And I think the argument, which is always put forward, is you can't put a value on life. Yes, you cannot. But also at the same time, these figures shouldn't be nominal, because a lot of the time, they've lost someone that's breadwinning, they've lost someone that was financially supportive of them, and also good things can come out, monetary awards, and there's positive things that can happen. And we're often told, Craig, and that we're told after cases what happens. Certain people are able to go on education courses, are able to do certain things with their life that they otherwise wouldn't have been able to do. Because bear in mind, they've lost the society and guidance of someone. And that can have a real meaningful impact on someone's vocational opportunities, someone's ability to concentrate and engage meaningfully with work. So a monetary award can help things get back on track as well. So I don't think it's meaningless. And I think these awards should be reasonable and reflective of the losses that the person has experienced.
Well, absolutely. And the whole point of it in the end, as you know, is to put the person in the position they would have been had this all not happened. Now, obviously, that cannot be fulfilled, in a physical sense. But yes, as you say, support, opportunities lost. this is what's achieved through these decisions such as these. So I'm certainly hopeful that Lynette's family are able to do what they can to move on from what was undoubtedly tragic.
I mean, we'll never heal the pain and the anguish and the harrowing experience that they've had. We cannot resolve that for them, and we completely accept that. But I think it has been comforting to the family to know that justice has been served, and the fact that this judgment could help other people in their situation, I think, has been really helpful and meaningful. And obviously, they didn't want her to have died in vain. They wanted something good to come out of it, and I think this judgment has been a positive development in the law, and I'm hopeful for other results like this.
Yeah, I completely agree from a pursuer's perspective, absolutely. And in fairness, what I was somewhat fearful of with this decision from a pursuer's perspective was that there would be this contributory negligence argument which came out in the Francis Hughes decision. Again, one that you had some involvement in. So listeners, we are involved in the big ones. But there was a bit of a backlash. Certainly,
that was a hard day in the office that day, wasn't it?
That was. I couldn't. I mean, I'm not going to go full pelt at Lord Clark. He reached his decision based on what he felt was just, albeit what he had said about contributory negligence in that case was a bit of a side note, having decided about the main points on negligence and causation against Mr. Hughes' family. But for those of you who are not aware of the case, that decision involved a gentleman who had severe alcohol issues and unfortunately died as a result of withdrawal symptoms, causing a heart attack. Am I right in saying, Elizabeth?
I think it was. I think it was actually a cardiac arrest.
And Lord Clark went on to say in that decision that the alcoholism, because it was, for all intents and purposes, self-inflicted by Mr. Hughes, he had contributed negligently to his demise, which, from a human perspective, I thought was not particularly nice to read.
I think my own personal view is that if you have an addiction issue and you're actively seeking help, that you should be admired and respected for that. The fact that you've recognised that I see it as a mental illness, a form of mental illness, addiction. That's my own personal view, and I know some people would think that is not correct, but I see it as a form of mental illness. And I think if you identify that and you want to recover and you're actively engaged in trying to recover, I think that is admirable. And I think it should be respected because it takes an incredible addiction. Unless you've experienced it, I don't think people really understand the depths of how difficult and how low you can go back to addiction. And I think it takes a really, really strong person to accept that they have a problem and to engage meaningfully in their recovery. So that's my view.
No, absolutely, Elizabeth. And I think similar things can be said for mental health as well. And there still is, unfortunately, taboo around it, but I think the world's getting a bit more sensitive to these things and looking at it with certainly more sympathy and willingness to help. Particularly with men my age and even younger, there's just this general reluctance to come forward and admit these things, which, as you say, is the strongest thing you can do.
Of course, showing vulnerability is a sign of strength, not weakness.
Indeed, well put. But you see, what I was wondering was whether the defenders might have taken a similar view.
Oh, yeah.
With
I was
suicide. But they didn't, from what I remember, which perhaps I'm hoping is an indicator that they too kind of agreed that Lord Clark's view on that was maybe not particularly humane. I mean, time will tell if such an argument's brought forward for a suicide case, but I hope I would be very surprised if that came up. But yeah, no, that's I do think that's worth pointing out, because you'll sometimes get these arguments that a lot of these things are self-inflicted by those who have suffered in the end, and mental health. In the end, you'll sometimes get people that don't help themselves with these things, but that's because they don't come forward for the help, unfortunately. So, but should hopefully cases like this lead to better outcomes for those. Okay, well, I did say we would. Well, it's not been me speaking; it's been more.
No, it's been collaborative. I can hear my wee one doing her alphabet just. I'm trying to concentrate, but yes, I can hear her doing her alphabet.
Oh no, she's doing well from the sounds of it. On that note, Elizabeth, unless you've anything further to say.
No. Thank you for inviting me on.
No. Thank you for taking the time, and I know is what is a very busy schedule to chat with me about this, and We'll see what more comes to our doorstep on these things. But
yes.
No, thank you again, and again, from a pursuer's perspective, well done. Good result for the clients in the end, and thank you.
Thank you.
And so thanks very much for those of you that listened into this one today. I hope to, I intend to draft a wee blog just explaining the decision in a bit more detail, and so if you want some more comments with maybe a bit of case law, if you're so interested, you can hopefully find that on our website in due course. But thank you again for listening or watching, whatever format you're on, and I'll see you next time.
Head to our website, lndmmedilaw.com, for more information.